Okay, it is 7 o'clock p.m. Central Standard Time, and it is Monday, May the 23rd, 2022. And welcome to week number three. 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 That means after this week, we will be halfway through this course. See how quick that goes. So you'll want to be on top. And I do want to remind each and every one of you one thing. Number one, it's very important for you to get your assignments in on time, so that you can maximize your points. Secondly, make sure that you pay close attention to what is said in the module, what instructions are given for the assignment in conjunction with the rubric. I have said before, and I'll keep saying it, and students ask, why do they lose so many points for not having citations in the body or credible sources, which is the same, is because we are preparing you for integrity. And that reflects academic integrity. I started with the academic integrity video during week 1, and many of you have had me in other classes, and you know how I am about APA. I've had students who come back to me after they graduate and let me know how much they appreciate me being dogmatic about APA. So it's very important. I have students all the time that say, well, the rubric didn't exactly say that. Yeah, the rubric does say that, because I tell you that without citations in the body, the information is not complete. Then I have to speculate on where you got the information from. Citations in the body provide support for your papers. That lets the reader know the source or sources that you obtain the information that you include in your paper. And it also minimizes plagiarism. You also want to have a lot of critical thinking in your papers, because we want you to be able to analyze, especially at this juncture where you're going for your bachelor's degree. You can't leave the school without understanding how to write critically, how to operate critical thinking, how to be a critical thinker. You won't survive. And so I'm not going to do a disservice to you by letting you skate along. So it is important for you to get into the habit of providing citations throughout your paper to support your statements. Where did you get the information? I'm not going to wonder where you got it from. You should be able to have it there for me. And there should be APA, citations in the body. If you cite a case, I have said this before and I'll say it again, please cite the official court case citation. It is usually in the module somewhere, or better yet, you can Google the case name and it will give you the citation, especially since most of these cases are U.S. Supreme Court cases. So it's very important for you to understand. These are landmark cases that we cover in this class. Also, you want to make sure that you do it correctly. So then you have a full reference page, which should reflect the citations in your paper. Finally, you should have conducted research to use the sources. Don't just use the textbook. I don't like to see students lean heavily on the textbook, because we want to teach you how to research. And it's very important for you to learn how to do that to be successful in your careers. And your writing is critical, your spelling, your grammar, all of that is critical in terms of advancement in the future. So in my classes, I'm very tough on those kinds of things. I don't play games with that. And if you want to do well in my classes, you've got to follow APA. If you don't know at this juncture, you should reach out for a tutor to help you. It is essential and important that you be able to do so. The final thing I'm going to say about that is that what we're really doing is preparing you to be able to follow instructions, the instructions of the module, the issues that I cover in the lecture to support, along with the rubric. And if you don't have citations, I'm sorry, you're going to end up with the 55 or less, because the rubric's going to put you in that. I will not put you in or just take a few points off for that. I won't do that. I refuse to do that. And any student who's been in my classes know that I won't do that. It is a disservice to you. Okay, so having said all of that, I'm going to also remind you, if you have problems, reach out to me. You know the rule about extenuating circumstances, that you can text me, you can call me or email me any hour of the day except the 25th hour. And that's how I roll with my students. All right, so let's get started. Let's look at the module for week number. Now, first, before we do that, let's take a look at the grade book so you can see the assignments, and I'll go and elaborate on those pretty much. Written assignment is search warrant exceptions. We'll talk about those tonight. I also provided you with some information, but that information is pretty much for Through the Poisonous Tree. But search warrant exceptions, we're going to cover in detail tonight. Reasonable suspicion, that's going to be something we also cover. And then your live classroom phrase that will be given out, okay? Let's take a look at the calendar real quick, so there's no confusion. Your course began on the 11th. We are now at the 23rd, and your initial post is due tomorrow. And Saturday, your reply post. And Sunday, the 29th, your live classroom phrase and written assignment is due for week 3. After we finish it, week 4, week 3 assignments will absolutely not be accepted. No way, shape, form, or fashion, unless we've made some previous arrangements before that. So don't ask me in week 4 or week 5, how do I get weeks 1 and 2 in? Yeah, you can't. You cannot. Very important. Okay? So week 3 ends the 29th. Week 4 begins the 30th, which is the Memorial Day holiday. Okay? And then you can see that the course ends a few weeks after that. On the 17th, that is the last day of class, all assignments must be in by 11:59 p.m. Central Standard. Very important for you to get this, because I have students every time that say, oh, I thought I had till the 19th, that Sunday. No, you do not. You do not. You do not. The 17th is it, not the 18th. And that's based on Central Standard, which is my time zone. All right. So most of you shouldn't have a problem, because you're either in Central Standard, most of you, and then if you're not, then you're in Eastern. And if 11:59 should come when 11:59 your time comes, it's 10:59. So basically, you have to just remember that we are 1 hour behind you. All right. Always remember that. So you have an advantage, actually. All right. So now let's go back and let's get to Module 3, the Fourth Amendment and Government Authority. So let's start by looking at the written assignment. I always start out by talking about this. Now, the activity itself provides 5 scenarios. Now, listen to me good. Please hear me. Read each scenario and discuss the applicable exception to the search warrant requirement. You got to do that for each section. Now, please cite your sources in each scenario. You hear me? Your paper should be 3 pages minimum, double spaced. All right? With a cover page, not 2.5, but 3 full pages. You can go beyond that. That's okay. And you're going to, so I would put scenario as a caption 1, number 2, 3, and you go over each of these. And we're going to discuss some cases tonight that will help you with these assignments. And then your reading, of course, as well as the PowerPoints that I've previously provided for you as well. So you'll have plenty of information to help you. Just remember, when I read each scenario, you should have something to support it. A case or cases are really pretty much what you should be aware of. And we will be talking about those specifics tonight. And remember, I told you, cite the full case. It is APA. All right, I said that. Discuss the applicable exception to the search warrant requirement. If no valid exception applies, explain why. Support it with appropriate, see it says case law. If you don't cite a case in each section, you're going to lose points for not citing a case in that section. Not only is it in the module, but you'll see it in the rubric. Cite credible sources and include a reference page and a cover page. All right. Now, let me look at the rubric. And I'm going to start by showing you the worst case scenario. Look at what it says. Incomplete or incorrect discussion. In the scenario, missing details on whether no valid exception applies and or missing rationale with appropriate case law. So if you don't have case law, it's going to be incomplete and incorrect. It's not a minor thing. It's a requirement. You got to do that for each scenario, each of the 5, and it should equal 3 pages. And it says if you don't have any credible sources and no reference page, and or, notice it says and or. So you say, oh, I had a reference page. You're still going to end up over here. You're still going to lose the points. Attempted citation. You're going to end up over here. The key is you want to end up over here. And you want to provide case law for each scenario. Each scenario requires case law. Case law, appropriately cited. Appropriately cited. I already told you how to cite it, and I'll be talking about that during the lecture tonight. Professional spelling, and 3 to 4. Let's say you did all of this, and then your paper was 2.5 pages. Then you're going to end up losing, in this section, you're going to lose 50% of the points. I don't think you want that. I don't think you want 50% of the points for this section. I don't think you want that. That'll pull your grade down substantially because it calculates itself. I have students all the time that say to me, I don't think it's that serious just because you look at it the wrong way. You're looking at it from the perspective that citations and references are not important. Citing the cases appropriately are not important. Yes, they are. All of those are important. Why? Because the school says so, number one, and I am encouraged by the school to teach you to be professionals. That's it. Remember my perspective: educated, professional, and ethical criminal justice students. Okay, so please get this and pay close attention every week when it says case law. And by the way, in the constitutional law class, to be honest with you, it is really one of the things I look for, because there's plenty of cases out here to support these. We don't give you tricky stuff. We give you stuff that's pretty well settled. Now, we lawyers, when we do it, we have to look at that stuff, but we also have to bring it up to date and stuff like that. I'm not requiring that of you. In other words, you don't have to shepherdize a case to bring me the most recent case. You don't have to do that. I did, and I have to. If I'm going to do some writing, which I've done, you will see I have to do that. So anyway, that's just an aside point. So what I want you to do, cite your sources, APA appropriately, as well as cite your cases using the official court case citation. The name starts out with the name, and it starts out, then it comes in with a number, then it has US, because these are United States Supreme Court cases, and then it has another number, and then in parentheses, it has the year. That's it. I'll point it out to you as we come. All right, so that's it. So I know what students are going to say. They're going to say, well, Professor Wright is really tough on me in that, and it was a little thing for me not to have citations and reference and cite the case appropriately. It's not a little thing, okay? Let's look at reasonable suspicion. We'll talk about that. This is commonly referred to as a Terry case, Terry stop. We'll be talking about that in just a few minutes. So you're going to explore reasonable suspicion and its application to suspicious people and vehicles. Again, the leading case here is Terry versus Ohio, which we will discuss during tonight's lecture. So you're going to look at this scenario, and then in your initial post that's due tomorrow night, explain and justify why you're able to stop John and his vehicle based on constitutional law. Once it's stopped, discuss what you should do next and explain why you'd be able to frisk the interior of the vehicle as well as the person. Then in your reply post, reply to one other post. All right. Again, your initial post is, by the way, you have to post first before you even will see the post, period. So be aware of that. All right. And that is due Tuesday night, tomorrow night, and Saturday night. Then your live classroom submission, which will be your key phrase, which you click on, and then you put that in based on what I say it is. And then your link, the link will be taken away. That is this link, which is where we are now, and replaced with the recording link, and I will be emailing that to you as well. Probably most of you don't use this because you see it here. You really do yourself a disservice when you're not coming to the live lectures, because then you can even ask questions that help you to head off potential problems. So we're going to talk about probable cause, reasonable suspicion, Fourth Amendment warrant requirements and exceptions to search warrant. And then we're going to deal with some common exceptions. And then we're going to close out with a knowledge check. Okay, there is a mid-quarter survey if you can take the time to do it. We'd appreciate that. That gives me some ideas about where you are. Okay, but I give you guidance. I can't break it down any finer. But I pride myself in laying out expectations starting in the open house and continuing all the way through to module 6. All right, so let's take a look at, oops, I didn't mean to do that. This is what I wanted to go to. I want to go to the announcements because I went to the calendar already. So let's look at the week 3 announcement. So for this week, the Fourth Amendment of Government Authority, I provided you with the PowerPoints for Chapter 9 of the textbook. And then we're going to deal with Terry versus Ohio. And then you have some other items in here that you can take a look at. Then we're going to deal with reasonable suspicion, the Fourth Amendment, and the search warrant requirement, and probable cause research starter. So we're going to do that. And then a reminder again that your lecture is now. And then you can also be aware that the discussion assignment reasonable suspicion one more time is due tomorrow night for the initial post and Saturday for the reply post. Finally, complete the written assignment search warrant exceptions, which I just talked about in detail, and it's due Sunday along with your key phrase. I repeat again, I say it over and over. The requirements are found in the classroom under the lessons tab and the rubric. I should also add what I say in this lecture. So let's start strong. Let's continue to be strong. Let's finish strong. And you know about my motto, adversity is the springboard to success. All right. And you want to make sure that you pay close attention to that. That's not a requirement, but I recommend it highly. It's right here. It tells you about what I went through to get to where I am now and why I am the way that I am. And trust me, the things I'm teaching you will help you succeed. I think that's what you're spending good money for and the kind of professors that you really want. You don't want anybody just to give you a passing grade. You're not in my class to get a passing grade. You're in my class to learn information and details. If you happen to do the assignments properly, you will get A and B. Remember, I already talked about that. All right. So let's start out by talking about two issues that you must be familiar with: probable cause and reasonable suspicion. Now, probable cause is kind of evasive, but probable cause is actually a concept that is not in the Constitution, but it's based on court cases. Remember, we operate on the basis of what we call STARE, S-T-A-R-E, decisis, D-E-C-I-S-I-S, which means that we base our cases in the present based upon the past, and we continue to use those cases by applying the law of the past or overturning the law of the past. And so you should be aware that probable cause is something that is very important. Now, ideally, when you deal with an arrest or search, you should have a warrant. You should have a warrant. And most arrests, though, and seizures are conducted without a warrant and are based upon probable cause or the Fourth Amendment exceptions, which we'll discuss in a little bit. So stay tuned. Now, so probable cause is kind of using the language of the Fourth Amendment that says no warrant shall issue but upon probable cause. And in order to get a warrant, you have to go before a magistrate or a judge with an affidavit, and the affidavit um, lays out, uh, it's a sworn document, and it lays out facts that are adequate for the trier of fact, who is generally a magistrate or judge, to determine that a warrant can be issued. Now, and so because of the fact that judges pretty much define what probable cause is determined on a case-by-case basis. As it says, the facts and circumstances before an officer are such as to warrant a man of prudence and caution in believing that an offense has been committed. So probable cause pretty much means that it's based upon probabilities. More likely the person did than not. And it's, again, based upon the, quote, reasonable person. Notice the language in Illinois versus Gates, 83 case that I'm familiar with. In dealing with probable cause, as the name implies, we deal with probabilities, as I already said. These are not technical. They are factual and practical considerations of life based upon what a reasonable and prudent person, not legal tactician, would believe. Okay, so it's kind of like you kind of know it when you see it, as one Supreme Court justice has said about obscenity, but it also applies to probable cause. Okay, and it is the standard that is necessary to arrest or support an arrest warrant. And you as law enforcement officers, or future law enforcement officers, or individuals in the criminal justice area have to determine, based upon the facts that are before you, that you are able to elicit and also provide in writing before a magistrate to get a warrant, or you're going to have to, as we say, make a quick decision as to when a crime is in progress. And so the point of the matter is that your decision will be based upon your knowledge of studying the law, as well as your experiences that you'll obtain over periods of time. Okay, so it takes a little while. Now, if probable cause does not exist, there is the level of reasonable suspicion. We're going to get into that, that you can temporarily detain and question someone. All right, so that's probable cause. So remember, probable cause is the bread and butter. However, in reality, I would gather to say that reasonable suspicion fits quite a bit. Now, the probable cause aspects of it fits within one of the exceptions, or either a judge getting a warrant. And there are reasons why the exceptions, which you will be well aware of before you leave this hour. Within the next half an hour, you will learn. I will cover that. So now let's switch gears and let's get to reasonable suspicion. Now, the Terry versus Ohio, a 1968 case, lays down some facts that these police officers were working as plainclothesmen, and they were familiar with the area, and they knew they were aware of shoplifters and pickpockets in the area. And so the Detective McFadden, one of the detectives, says it could not precisely say what drew his attention to John Terry and Richard Chilton. But the detective observed from about 300 to 400 feet that they walked back and forth. It looked like they were casing, peering in the window and walking back and forth. And so after a number of times looking in the window, they stopped Terry and McFadden because they thought they were doing what I just said, casing the joint. And they grabbed Terry and turned him around, patted his exterior. Okay, patted his exterior. Now listen to this, and his overcoat breast pocket, and they felt a pistol and removed it. They also patted down the other guy's clothing and found another pistol. So remember, these are pat downs. So at that point, then they can seize the item, and based upon the suspicions that these guys were casing the joint to commit a crime, as well as discovering during the pat down, and you'll discover that the purpose for the pat down is to discover if there are weapons, because if there are weapons, then the individuals could present a danger to the police. So in order to protect the police and their safety and others, they are allowed to pat down and then reach into the clothing where they felt the weapon. And at that point, then they were arrested and charged with carrying concealed weapons. All right. So anyway, the defendants said, no, 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 no. They said, you unlawfully stopped them. And the trial court dealt with the issue between an investigatory stop and frisk and between a frisk of outer clothing. Well, the appellate court affirmed the decision, and the Ohio Supreme Court denied the appeal, saying that there was no constitutional question. Well, United States Supreme Court granted what we call certiorari, or agreed to hear the case, and they affirmed the lower court's findings. So what happened is that the Terry case established the well-known Terry stop, which is an effective investigative tool that is now used and has been codified in many legislations across the United States, in all states. So in a 8-to-1 opinion, which is pretty settled opinion, Chief Justice Earl Warren provided the following instructions to law enforcement officers, and I'm going to read them. It says, we merely hold today that when a police officer observes unusual conduct, which leads them to conclude that in light of their experience, that criminal activity may be afoot. That's a famous phrase we law students remember. Crime is afoot. What that means is not the body foot. It means that it's taking place presently or in the process about to take place, and that the persons with whom that they're dealing with could be armed and considered dangerous in the course of investigating. Identifying oneself as a police officer and ask reasonable inquiries. And the point of the matter is why are you there, what you're doing, and so forth. And so in the process, the officer is entitled to reasonable protection of themselves and others in the area to conduct a limited search of the outer clothing of such person in an attempt to discover weapons which might be used. And the search is what we call a reasonable search under the Fourth Amendment, and any weapon seized can be used as evidence against that person. All right, and that's pretty much it. So in years after that, it was made clear what temporary mean. How long does it last? Well, it would be based upon how much time, based upon all the surrounding circumstances, it took for the officer to be able to make it clear that they had to hold them for that length of time. Unreasonable came to be more clarified in 2015 in the Rodriguez case, and it's roughly 20 minutes. So it's something like that, where a detained person is released if probable cause is not developed within that 20 minutes. That's kind of the rule of thumb. And so the pat down, notice what I said, pay close attention, is limited to the exterior clothing, and an officer may only reach into the clothing to remove what they reasonably believe is a weapon. Now, reaching into clothing is a search and more intrusive than a frisk. So you pat down and then you say, oops, there's a weapon here. And then you reach down and you grab it. And it says nothing precludes an officer from asking for consent. You can also ask for consent, but if they don't, you don't have to. The decision created reasonable suspicion that that officer determines based on their experience and knowledge to temporarily detain and pat down the person. Now, be aware that someone might say, well, okay, what if it's not the outer coat, but you feel it inside the coat? Well, that's the same issue because you still feel it, but in order to gain access of it for it, you might have to unzip, unbutton, or something, or reach inside. Maybe it's an inside pocket. It's not an outside pocket. So Terry has made it clear as we consider Michigan versus Long that it was extended to motor vehicles. So you can search motor vehicles and permit police to do a brief look for weapons and underneath the seat where the driver had just reached, maybe in the glove compartment, and maybe even in the back seat if there are other passengers, but not the trunk, not the trunk. So 1993, the Dickerson case approved what we call plain field, which permits officers to remove suspected contraband. So let's say you pat them down, aha, what's this lump here? This bag of stuff here. You can now go into that. Not initially, but now since Minnesota versus Dickerson. So the key thing is you need to understand probable cause is one level, and there has to be an exception to probable cause in order for the search to be legal. But reasonable suspicion is based upon a brief period of time, and we deal with that. Okay, so now notice this. See the citations, the number, the name of the case. There's a number, there's US, there's another number, and then the parentheses, 1949, the year. So what that means is this Brennegar versus United States was found in volume 338 of the United States Supreme Court books, and it starts at page 160, and it was handed down in 1949. So that's what that all means. All right. Let's go to the Fourth Amendment and warrant exceptions. All right, now, so as I already said, that you have to get a warrant, and it tells you how to, about affidavits. I already covered that. And the Fourth Amendment does not prohibit searches or seizures. Rather, it prohibits unreasonable search and seizures. Although it's not practical for law enforcement to have a warrant for all arrests, that's why we have exceptions, and exceptions that'll make sense when I go over them. The warrant is preferred. And then I already talked about the affidavit and appearing before the judge, so I won't repeat that anymore. Okay, and then this is information here that basically is like a hodgepodge or explains some of the things there. All right, so let's talk about the warrant requirements. So in order to obtain a warrant, the specificity must be in detail. It must specifically determine the individuals, the location, and all of those things. So it must include a description of what you're looking for, such as, let's say, you're looking for, as they say, an air compressor, red, and a yellow flexible hose attached. And there's some specifics, car model, serial numbers, so forth. When police seeking narcotics, um, they describe and don't just state heroin, methamphetamine. The officer would have to describe what it looks like, a fine white crystalline powder consistent with cocaine. So give some specificity. So sufficient particularity clause applies to the area. So it has to be a description of the area where the person is going to search. And it could be satisfied if the location includes an address, the color of the structure, the type of structure, and so forth and so on. And it's important to have as much specificity as possible. The scope of the warrant is the boundaries, the extent to which the person is authorized to search. For example, the scope of the warrant for burglary case, the one mentioned above, may be to search the residence for specific evidence relating to burglary. If during the search for the burglary evidence, other evidence such as narcotics, they can't change the scope of the original warrant and start searching for more narcotics. Searching for narcotics would not be within the scope of the original warrant. So you have to pretty much lay it out as particularly clear as you want, as necessary. Once the person or items are seized, as described, the warrant includes an affidavit, and I already talked about that. And that's why it's important for your written communication to be very important, because affidavits usually are derived from police reports, but they're less detailed than police reports. Rather, it's written in chronological order and includes only the content that a judge would be interested in to determine if probable cause exists. And then this shows you a sample search warrant, which I won't click on. All right. So what's the time frame? Well, most warrants are served in a timely manner, generally within 5 days. So, for example, Tennessee law says that timely execution must be within 5 days after it is signed by the judge. When executing the search warrant, law enforcement must knock and announce before entry. We're going to, talk about the fact that no knocks are on the way out, hopefully. The Breonna Taylor case is a classic example of that. Everybody's familiar with that in Kentucky, where a couple was sleeping and the police ended up killing an innocent person sleeping because they were executing a no-knock warrant. Because a no-knock warrant doesn't require announcement or either knowledge, but it's pretty clear that they're very dangerous. And many jurisdictions, and I think if I remember correctly, the federal law, the George Floyd law, is attempting to do away with no-knock warrants, but many departments have already begun to move away from that. So once executed, a search warrant must be left with the owner or occupant. If nobody's present, it must be left at the location. So a copy left with the person or persons on whom the search warrant is served, A copy of the signed affidavit and search warrant are filed with the court, and the affidavit is available to defendants when they file their discovery motion to determine the extent to which this warrant was valid. And so states vary, but remember, the key thing is reasonable search. Okay. All right. So, and then these are some cases that are listed here. All right. So now let's keep moving on. And let's talk about the Fourth Amendment warrant requirements. Oh, we did that. My bad. So let's go down to, well, we're going to skip, well, let's do key terms for right now. And then you can go over these yourself. But I just want to point out to you that you can do these flashcards. All right, so you click continue. Unreasonable search and seizures. The Fourth Amendment does not prohibit search and seizures. Rather, unreasonable search and seizures means that probable cause and specific information is needed. Then you can go to the next card, an affidavit, and then you'll do that, and it explains that too. So you can go over those as well. All right. So now I want to get to the last part, which we have about 15 minutes, the exceptions. And I want to talk about these exceptions because they're important for your assignments for this week. So as I said, most arrests or searches take place in a situation where it is impractical to obtain a warrant before the arrest or search. And the exceptions commonly applied include the Terry frisk, which we just talked about, the search incident to arrest, vehicle searches, consent searches, plain view, garbage, probation or parole searches. All right, and we're gonna talk about that. All right. So let's start with plain view. Now, it means what it says. It said there are three important things though that must be recognized in order to deal with the issue of plain view. First, the officer has to be legally present. Second, the discovery or observation of the contraband is inadvertent. They just came upon it. Now, remember, legally present and inadvertent. The items to be seized must be readily apparent contraband or evidence of a crime. Now, I think we had a discussion about a head found in a refrigerator. You might remember that one. Remember that discussion. So the question is, was it in plain view? No. Because remember, the police officer was asking to go to the bathroom, but he took a detour. So he was legally present in the facility. It was inadvertent, but readily apparent. All right, because he was out of his scope. So the plain view exception, as in 1982 Washington versus Chrisman, where a Washington State University police officer saw an underage student leave a dorm room with a bottle of gin and stopped and asked him for identification, which was in his dorm. The officer followed him to his dorm. When the door opened, he obtained the identification. While the door was open, he saw the roommate nervously placing a small box inside a cabinet. The officer also saw suspected marijuana seeds used to smoke. And the officer entered the room and confirmed his belief that there was actually paraphernalia and marijuana being smoked. And he read them their rights, placed them under arrest, and which they waived. and they consented to a search of the room, which revealed marijuana. Okay, so he argued that the officer following him to the dorm violated his Fourth Amendment. Well, the Supreme Court said that's not true because and affirmed the plain view doctrine, which inadvertently observed this narcotic from where he had a right to be, because he was invited. All right. Now, so it has to be those three things. Consent. Consent has to be, first of all, satisfy three elements. Person must be granted the consent and has the authority to do so, grant that consent. It must be known and given voluntarily. So the question is, in order for a search to be based upon consent, it has to be quite clear that all three of these elements were there. So we deal with the Mendenhall case, and it was determined whether consent was voluntarily given by this young lady when she was approached by DEA and at an airport, and they suspected her carrying narcotics. And they approached her and asked her for ID and for airline ticket and questioned her about how long she had been in California. Well, she produced her ID and airline ticket, which was the airline ticket was in a different name. The agents asked her if she would accompany them to the DEA office for further questioning. And so she agreed to accompany them. The agents asked consent to search her person and handbag. And she said, okay, go ahead. The agents also explained she had the right to refuse. But a female officer arrived and searched her, which was a good thing, and 2 packages of heroin. She argued the initial contact was not voluntarily given. The trial court disagreed, but the appeals court overturned and concluded the consent was not voluntary. The United States Supreme Court concluded the consent was voluntarily given, and I'm not surprised to hear that one, and said that she willingly went to the DA office and consent to search her purse was given and freely, and that there were never no threats or force or anything like that. And so the court concluded at no time was there any discovery. Also concluded at no time before the discovery of the heroin was she seized. When determined if consent is voluntary, the court will examine all of the circumstances, or as we refer to as the totality of the circumstances. All right. So the key thing that you need to be aware of as we continue on is that it is important to determine how free the person was and if they had the authority. Well, she had authority to grant it, but there may be some situations where others might not have that authority. You can look at the Illinois versus Rodriguez case for that detail. All right. All right. It says, although not required, obtaining consent in writing is another tool, but written forms are commonly used by law enforcement for this purpose. Video cameras also can be used, and that's one of the good things about it. Another exception is the automobile. Warrantless searches, and we kind of talked about that a little bit, are another common exception to the search warrant requirement. It can occur with consent, as I said, or incident to a lawful arrest, or based upon plain view. And automobiles, because it's movable and easy to quickly move along, there are 2 reasons for the exception. The Carroll case, a 1925 case, permitted law enforcement to search a motor vehicle where incident to a lawful arrest. The reasons allowed is that without a warrant is that the vehicle, first of all, is mobile, and a lesser expectation of privacy is expected in a vehicle than in a residence. And then so the Carroll doctrine continued and applied in the New York versus Belton case in 1981. All right. Consistent with Carroll and Belton, the Gantt case, it modified, matter of fact, take that back. Consistent with the Carroll case in Belton, searches of automobile with no other reason but for arrest continued until Gantt in 2009, and the court restricted the exception after Gantt when a suspected drug dealer with a warrant out for his arrest was arrested after he immediately exited and began to walk away. Officers searched the vehicle and found cocaine in a jacket pocket. He objected, and the court agreed with Gantt and modified the automobile exception in two ways. It says first that the arrested person is unsecured and within reaching distance of the passenger compartment, or the officer having an articulable belief they will find evidence, i.e. Underlying offense inside the automobile. So there's no blanket policy, but that's pretty much how it works now. Search incident to a lawful arrest. Of course, when a person is under arrest, the officers may search the person of that individual and their immediate belongings or in areas that are immediately accessible. And so no other justification outside of an arrest is necessary to conduct a search incident to an arrest, though. For example, in the Robinson case, police arrested Robinson for a traffic offense, searched him, found a crumbled cigarette pack which contained heroin. His defense argued no destructive evidence related to the offense nor weapon could be found inside the cigarette pack. The court disagreed and the search was good. And then the Chimo versus California 1969 case examined if the search of residence was unconstitutional. The court found the search of the house was unreasonable, but the search of the person himself within the immediate area where they could destroy evidence, then what they call the lunge reach rule. In other words, an area within they can lunge or get to. And then Mincy versus Arizona, they came out when I came out of law school 44 years ago, dealt with another exception aspect. All right. Parole searches, probation officers, individuals who are on parole, while they serve the remainder of their parole, they don't enjoy the same protection of the Fourth Amendment, and the limitations were examined in Griffith versus Wisconsin. The court affirmed the warrantless search of a probationer's home, but their agent upon reasonable grounds for the presence of the contraband, because that was part of the conditions, remember. This applies to the agent and does not extend to law enforcement officers. However, law enforcement officers may accompany the agent at that time. So that's just one. And then the Sampson case you can look at for more particular issues. 3 more minutes here. And then finally, garbage. The search of garbage. Remember, when you throw something in the garbage, you've abandoned it. And you don't have to get a warrant to go through somebody's garbage. That's the point I'm saying to you. When I say that, I'm saying it from the standpoint, not when it's in your house, but when it's outside and placed like outside the home in that case then. All right. And then these are some cases that go with that. All right. So now, these are some common searches, which we've kind of talked about, but you can take a look at it and you'll see these are some that are usually encountered by law enforcement. We talked about Terry. We talked about vehicle searches, plain view. We talked about probation or parole, search incident to arrest, consent searches, and garbage. And then these are some others that you might, but the ones with the asterisk are the ones we covered already. So those are some that are pretty common for law enforcement officers. The knowledge check, again, this is for you. And what is the level of proof needed for an arrest or a search warrant? Is it preponderance? Is it probable cause, reasonable suspicion, or beyond a reasonable doubt? By the way, if you get the first one and the last one are standards in cases. In criminal cases, beyond a reasonable doubt. In civil cases, mere preponderance. So it's one of these two, but you better get this one because that's it right there. All right. So I'm not going to go over any more, but you can study those for yourself. All right. So that's it. And I am going to give you a phrase, and it's really three words. It's search warrant exceptions. Search warrant exceptions. Say it one last time. Give me search warrant exceptions to get your points. If you don't have all three, you won't get them. All right. So I'm going to say good night to you. And again, pay close attention to what I talked about earlier. It's very important going forth as we reach the halfway point in this course. Let's get on track and let's stay on track. All right. And please listen to the lectures for details and information. So I'll see you next Monday at 7:00 p.m. Central Standard Time. Have a great week and stay safe. Get that work in. Good night.